This, our organization is divided into teams. So the foster care team is just one of the many teams that we have, and the other ones are like, we have a healthcare team and community integration team. The foster care team does more broadly. We can be appointed just as attorney ad litem on any case. We are appointed to a lot of cases of kids in TJJD around the state, so we're statewide, but we do also get appointed to a lot of cases specifically to deal with special education, which is what we're going to be talking about tonight. The PowerPoint has most of the information you're going to need on it, so there are spaces to write in on the side, but it's a very detailed PowerPoint, so you should have everything right in front of you. The Texas Juvenile Justice Department, so it's like a juvenile justice. And if I remember talking in acronyms, please just stop me because I'm often like not aware that I'm doing it. So those are the goals of our presentation tonight. And so our general goal is just to understand the educational rights of children and their advocates, and the responsibilities of school districts to provide specific services to children in special education. We're specifically going to be talking about the things in point number 2. So we're going to be talking about getting school records, requesting evaluations, ARD meetings and IEPs, which I'll explain later, and also protecting students' rights in disciplinary proceedings, and we're going to talk about transition to adulthood as well for older kids. So I'm going to start with an overview of special education. The first point is just the special education law, the sources of special education law. IDEA is the Individuals with Disabilities Education Act, and that's relatively recent. It's a federal law that was enacted in 2004, and IDEA provides increased protection for kids, and we'll talk in a couple places about where IDEA provides enhanced protections, but for your future reference, those are the sources of special education law. And then the purpose of special education law is to ensure that all children with disabilities have available to them a free, appropriate public education. So from now on, I'm going to call that FAPE. That's a common acronym for that. That emphasizes special education and related services designed to meet their unique needs. And specifically, the second part is really important as well. These services have to be in place in order to prepare them for further education and independent living. So that those goals have to be in mind when the services are enacted. And then the second purpose is just to ensure that the rights of children with disabilities and the parents of those children are protected. So to be eligible for FAPE, the Free Appropriate Public Education, the student actually has to meet one of several enumerated disabilities, and then by reason thereof need special education related services. So some of the disabilities that were enumerated are listed here. There are also others, but these are the primary ones. So IDEA, the new federal law, guarantees that all students with disabilities aged 3 through 21 have the right to free appropriate public education. And 21 does mean 21 at the beginning of a school year, so we might have a kid who's 22 because they were 21 in September, they're still entitled until the end of that school year. However, you can also have kids who, if they graduate early with a regular high school diploma, they would lose their entitlement at that point. And then, so this is the main case law on the matter that kind of defines what schools have to do. So it says that the IEP, which is the Individualized Education Plan, and I'll talk about that a little bit more later, has to confer meaningful benefit, which means that it has to provide for significant learning. So it doesn't mean that the school has to do everything they can possibly do in their power. This is the standard that they have to meet. And that really means the IEP has to be reasonably calculated to enable the child to benefit. Generally, what meaningful benefit means in terms of the actual form, they have an individualized education plan, and we'll talk about that later. And courts seem to have held that meaningful benefit just means that the child is like progressing towards the goals that are in the individualized education plan. So as long as there's some progress and some movement forward, they are getting meaningful benefit. We can skip over this slide. And then parents and surrogate parents. So who is a parent? A parent can be considered many different things. It's not just the biological parent. So it can be a biological or adoptive parent. It can be a foster parent, unless certain state laws might prohibit it from being a foster parent. It can be a guardian who's authorized to act as a parent. or a person who's acting in place of a parent. So the general idea behind this is it could just be a parent is not simply a biological or adoptive parent. Let's skip this slide. My slides seem to be slightly different. So foster parents under Texas law have to be given preferential consideration when being appointed as a surrogate parent, so schools will consider foster parents first. They may also act as a parent if the child has resided with them for at least 60 days, if they completed training for surrogate parents like this one, and if they have no interest that conflicts with the child's interest. So the district must make reasonable efforts to ensure assignment of a surrogate parent not more than 30 days after the need arises. The criteria for selection are, it cannot be a school district employee or any agency involved in the care or education of a child. So importantly, this means that CPS cannot be a parent of the child. It cannot be anybody that has a personal or professional interest that conflicts with the interests of the child. Whoever is appointed as a parent must have the knowledge and skills to ensure adequate representation of the child. And then the parent must represent the child in all matters relating to identification, evaluation, and placement, and provision of FAPE, which is the free appropriate public education.
And I'll just intervene where it comes in very handy for you guys to go through this training and be certified by Tina's agency is when we have children in a residential treatment center, because they do not have a quote foster parent who can step up on their behalf, as you know most kids do, and the staff at the RTC are not allowed to make those educational decisions for the child. So that's why we started having this training in the initial volunteer class, so that you're already certified, so that in the case where you have a child in an RTC, you already have your certificate where you can step in if necessary.
So here are just the duties of the surrogate parent under Texas law. The surrogate parent has to complete a training program like this one, must visit the child, must consult with persons involved in the child's education, which from my agency means that surrogate parents have to consult with us or the other attorneys ad litem, which is a really great benefit for both parties, I think. They have to review the child's educational records, attend the child's art committee meetings, which occur once a year or more often if needed, and then exercise independent judgment to pursue the child's interests and exercise the child's due process rights. So the training program for surrogate parents and foster parents provides an explanation of state and federal special education laws. So really this is the training, so we're going to be learning about that as we go along, so I don't think I need to detail exactly what the training is doing, so we'll skip this slide. And then this is just more details about the training. So disputes over appointment of a surrogate parent. So oftentimes disputes over appointment of a surrogate parent comes up when a foster parent wants to be appointed as a surrogate and the school disagrees. So the school district has to develop procedures initially for analyzing whether a foster parent has an interest that conflicts with the child, and therefore whether or not it's appropriate for the foster parent to be the child's surrogate parent. They can't have a financial conflict of interest, however, by virtue of serving as a foster parent. So being a foster parent alone does not mean that you have some interest that conflicts and therefore eliminates you from being a surrogate parent as well. Nor do issues of quality of care constitute a conflict of interest. Those just have to be reported.
What would be an example of something that would be a conflict of interest for a foster parent?
Well, so the foster parent, for example, might have a close relationship with the school from having another child at the school, which may develop some sort of conflict of interest. Also, if the foster parent were on the school board.
Okay, I see.
Anything like that that could just potentially mean that the foster parent would make a decision that they weren't making solely based on the interest of the child. So as I mentioned before, a dispute often comes up where the school does not deem the foster parent fit to be a surrogate parent. In these cases, the school district has to provide the foster parent with written notice of their denial within 7 calendar days. The written notice has to specify the reasons they're being denied and also inform the foster parents of their rights upon denial. So So the court also has authority to appoint a surrogate parent in addition to the schools. This is the jurisdiction that the courts have in order to appoint a surrogate parent, and in some cases this will come into play with districts that might not be very good at appointing surrogate parents or schools that don't want to have to deal with it, and so in those cases, often the attorney in the cases will request that the court do it instead.
And the way that we handle it within our court system and our agency is if you want to make a request for that, we discuss it with CPS at our monthly staffing. We discuss it with their current attorney ad litem. And then either the attorney ad litem or CPS will draft up the paperwork and present it to the judge. And the judge usually signs it.
So as Ms. Reeves mentioned before, it's really helpful in cases to have CASA as a surrogate parent. So these are the requirements which CASA volunteers have to meet to serve as a surrogate parent. The child has to be in the conservatorship of the department, obviously. The CASA volunteer has to be a guardian ad litem, and they cannot be acting as the child's parent under separate provisions of the education code. It's really beneficial. In addition, we talked about the RTCs and how it might be really helpful in those cases for you guys to be surrogate parents. Other reasons that it could be beneficial is because it's continuity for the child, so they're not having some random stranger that they've never met before come in and now be acting as the surrogate parent. You guys often know the children better than a lot of outside parties must be. You have to report to the court anyway, so those procedures are already in place, and you already have a professional relationship with many of the people that are already in the child's life and in the child's case. So surrogate parents have access to records. Parents, and from now on when I say parents, it means the numerous parents that we talked about before, not just the biological parent. But you have a right to see copies of all the records. You can write a letter asking which records they keep, and then follow up with saying, okay, now I want number 1, number 3, number 5. But you must have the records before an ARD, which is a certain type of meeting at the school that we'll be talking about later. So you have the right to records in a certain amount of time within 45 days, but if the ARD is scheduled in 30 days, then you have the right to view those records before the ARD meeting regardless. If the records are incorrect, you can ask the school to make the correction, and they have to do so, and if the school refuses to make a change, you have the right to a hearing and to a statement included in the record that you believe that something is incorrect. So evaluations for special education, if the school doesn't think that the child needs to be evaluated, they have to send written notice about this decision and the reasons for these decisions and the parents' rights in these cases. Parents have to consent to all evaluations, but not everything is an evaluation. So there are certain procedures that schools can do that don't constitute evaluations, and they thereby don't have to get parental consent. So these are some of the things that are not considered evaluations. And when a child moves to a new school, whether it's in the same district or in a different district, the school has 60 days to conduct the initial evaluation.
And I think have y'all found that a lot of the reason that schools will deny a child to be evaluated is because of the cost to the district? I mean, what have you found in your majority?
In my experience, I haven't found that specific schools are just denying for a certain reason. It might just be that there's a delay, or that they think that the child's prior records are sufficient, and that they don't need to do a new evaluation, but they do. And so if you ask for that, generally they're pretty compliant.
So if the child's under the CPS conservatorship, then the parents that took the child away from, are they included in these people that have to get permission?
No. Once a surrogate parent is appointed, that is the parent
Okay.
who has to make the child's educational decisions.
Okay.
So the evaluations, the purpose of the evaluations is to determine whether the child has a disability, and then also their educational needs and what services might be put in place to support the child in the educational setting. So the report has to include an assessment of the educational needs, the need for related and other special services, and also the need for positive behavioral supports, which we'll talk about shortly. So the evaluations, as I mentioned, you have a right to review all the records and evaluations before an ARD meeting, which we'll be talking about again. I know I keep saying ARD, and but that will be explained, I promise. But you should review the records before an ARD to make sure they're complete, also to become familiar with everything that is being provided to the student or not being provided to the student, because an ARD meeting is where those changes take place. And they generally occur once a year, but they can occur in other situations if need be. It can be difficult to get an ARD more than once a year because often schools just they have to schedule them for all the children, and so if your child has had one and there are other students who haven't, it can be difficult to say, well, we need another one for those changes. So it's really important to review these records and make sure you know what changes need to be made before you go to the
And
meetings.
some examples of when an ARD might be necessary is if a child's health deteriorates. So that could be a factor. If there's been a significant trauma that's happened that's affecting the child's education. We've had one case where the child was a sexual abuse victim, and the large classrooms really affected her, so we had to step in and have kind of an emergency ARD as soon as possible to see how we could get her in a smaller
Is this the
classroom.
one
We're
that
having
got
aid.
homeschooled?
It's a different one. She ended up getting an aide assigned to her that sat with her and kind of helped keep her calm through the class and could notice if she was starting to stress out, and that really helped. So
ARDs are
that's just some
also
examples.
meetings that take place. So one of the main goals, at least as attorneys, is, and for you guys as well, is to get your child into the least restrictive environment. So if they don't need to be in a secluded campus and secluded classes and all special education campuses, and you think that they're ready to say have 3 special ed classes and 2 regular classes, or they're just fully ready to be reintegrated into the general education curriculum, the ARD meetings is where that takes place. So independent educational evaluations is if you agree with any evaluation that the school does, you can request an IEE, and the school has to pay for one. What is really an important point to take away from this for surrogate parents is that the school has a list of criteria for who you can get the independent educational evaluation from. And they will oftentimes say, okay, here's the name of this person, call them and go do your independent evaluation. And you don't need to use the school's recommended person. You need to find somebody that fits the school's criteria, but not use necessarily who
They recommend.
And it can often be better to use somebody that is not doesn't have a direct relationship with the school, and all their referrals aren't going to this one person. So when we get a case and we think that there needs to be an independent evaluation, we'll ask for the school's criteria and then select somebody based on recommendations or based on other research that fits the criteria that the child can go to. There can also be reevaluations if you disagree, and so the school has to ensure a reevaluation if they determine that the educational or related services and needs, including the improvement in academic achievement and functional performance, warrant reevaluation, and if the child's parent or teacher requests a reevaluation. And then those are just the timelines in which they must occur. They have to, in the same way that the school has to get parental consent to do an initial evaluation, they also need parental consent to do a reevaluation, except if the school can demonstrate that it had taken reasonable measures and there had been no response. So we've mentioned ARDs and IEPs a lot, and I'm sure you guys are wondering what those are. So we're going to talk about that process. So the ARD stands for Admission Review and Dismissal Meeting, and that is somewhat misleading, I think, because dismissal, you think the kid's getting kicked out, and that's not what's going on in an ARD meeting. Many things can happen in an ARD meeting. And so the ARD meetings have to happen once a year, and the parent has to receive 5+ school days before the meeting of notice. But the school has to attempt to work with your schedule. So if they give you 5 days and you can't do it until the following week, the school really should make an attempt to work with you on that. So these are the list of people who attends and the members of the committee. And they generally make up actually each one vote if there's some conflict, and the parent and student actually equal 1 vote combined.
So they have to agree.
Yeah, exactly. Otherwise, I don't know how they do half those. But so the member not all members have to be present if there's an agreement in writing, but if the area, for example, if you're specifically talking about the kids' English class and their English teacher can't be present, they have to give some sort of written documentation about what's going on. And in those cases, it really is best to ask to reschedule if at all possible. So the IEP, which is an individualized education plan, it has to include the present levels of academic achievement and functional performance. And it has to have a statement of measurable annual goals, including both academic and functional goals. So in simple terms, the IEP has to address the goals, the placement, the FBA and BIP. And FBA stands for Functional Behavioral Assessment, and BIP stands for Behavior Intervention Plan, and we'll be talking about those a little bit more too. So these are what they do, and the statement of the measurable goals is really important because oftentimes one mistake that we see a lot is that they state very broad goals rather than stating
Specific.
how it's going to be measured. Exactly. So the child must improve in English. That's way too broad. You have to say they're going to improve in identifying characters, identifying storylines, and this is going to be measured by 3 out of 4 tests, or 3 out of 4, getting 75% correct on the next evaluation.
Or, it could be something as simple as learning a certain number of sight words and being able to still pass them, a week later, or something of that nature.
Yeah.
And also the individual education plan, with you as the CASA volunteer for these kids, hopefully will know the kids better than anyone else attending these meetings. This is a really good time to kind of think outside of the box of what will help this child. One example we did for my older son when he was very little, because he had seizures, he was very shy. And in 3rd grade, he was having them a lot. And I was more concerned about recess because it's a, huge playground and there's only 1 or 2 teachers, out there, and he's shy and, doesn't hang out with a big group of friends. So we came up with what we called a buddy system. And we did this through it was an idea I brought up at the art meeting. And so we came up with a cute little paddle type thing. And every week, one of the kids in the class was assigned his buddy. And that buddy was responsible for playing with him at recess, sitting with him at lunch. And it was their job to go get help if something happened. And so they thought it was cool to be the assigned buddy. It helped him make more friends. And it, gave the teacher some peace of mind. So, again, you can think outside of the box. What's going to help your child? So it might not even be the education, but just keeping them safe at school. If they need someone to go with them to the bathroom because they have anxiety attacks, if they may have been assaulted in a bathroom or something. Think about the triggers for your kid, what's going to help them succeed, and that's where the IEP is where you want to put those details in.
So I mentioned a little bit earlier that it's really important, the least restrictive environment is important. Schools need to have a continuum of placements, and these can be different in different districts. In one district, the most restrictive placement could be a completely separate campus where the child has to take special education bus to that campus. And in another district, their most intense placement might be, well, you go to the general education campus, but all of your classes are in one classroom and you don't get to move around the campus. So those can be different, but it's still really important, no matter what your situation is, to keep considering on a continual basis, is this child in the least restrictive environment? Could we somehow, with services or supplementary aids, take them to the less restrictive level? So this is just stating that there's generally a presumption for mainstreaming, a presumption that, to the maximum extent appropriate, children with disabilities should be educated with children who are not disabled and have access to the general curriculum. So special education classes, separate schooling, or any sort of removal can only occur if there's the nature and severity of the disability is such that education in regular classes with the use of supplementary aids and services cannot be achieved satisfactorily. So that's underlined because it's not just this kid can't operate in a regular classroom, let's move him to special ed. It's okay, now we need to give him this service and this service and this aid, and with all of those, he still can't operate in the general education classroom where it's being disruptive, then special education might become a consideration. The presumption for mainstreaming can be overcome if the child is so disruptive in a regular classroom that the education of other students is significantly impaired also. So the primary consideration is obviously the child with a disability who would be our client, but it's also the consideration of the other students. So if he's just too disruptive, then the child can be removed. So we talked a little bit about what IEPs can include or should include. The IEPs must include a statement of any individual appropriate accommodations that are necessary to measure academic achievement and functional performance. Or if the IEP team determines that the child take an alternative assessment, then the statement of why the child can't participate in the regular assessment and how the alternative assessment is appropriate for that specific child. So another thing that the IEP should consider is assistive technology. And assistive technology generally doesn't include things like reading glasses, but it would include a special computer or a calculator or communication board or something that is just not considered as mainstream as reading glasses or hearing aid.
For example, if they're horrible at math, we've had it to where they're allowed to use a calculator. During English, they're allowed to use a dictionary to help them with spelling, things like that.
So I mentioned that a lot of changes can be made in the ARD meeting, but that it might be difficult to get a second ARD meeting if you've already had your initial one. There are possibilities to make changes to the IEP after that, and that's that you can agree and make those changes in writing, like a written document or amendment to the initial IEP. And that can be made either by the entire team or by amending rather than redrafting the entire, so you can just put something on the end that says this is the amendment and then having everybody agree on it. And upon request, the parent has to be provided with those amendments as well. So you should make sure always when there's a change that doesn't occur in an official process like the ARD meeting that you have all the updated documents. So behavior and discipline. So zero tolerance isn't the law in Texas anymore. And that was amended pretty recently to require that all disciplinary removals now consider a set of factors rather than just saying X behavior occurred, you're removed from the school process for however long. So they have to now consider a self-defense, intent or lack of intent at the time the student engaged in the conduct, the student's disciplinary history, and also a disability that substantially impairs the student's capacity to appreciate the wrongfulness of their conduct. So the new federal law IDEA provides more protections for longer removals, and that's split into under 10 days and over 10 days. So in that over 10 days category, IDEA provides increased protections, and that can be 10 consecutive days, or it can be a pattern that keeps occurring that means the child is out of school for more than 10 days. So disciplinary placements, these are just examples of removals. It can be suspension, an alternative education program, expulsion, or in some circumstances in-school suspension. But that can count towards the time of removal as well if the student's not receiving the services, if they're just being put in in-school suspension and not continuing the regular education plan, then that would count towards those 10 days. So for suspensions or removals for less than 10 days, the school has to hold a conference with the parents, the principal, the teacher, and the student. And the student has to be given oral or written notice of the reason for their removal and an opportunity to explain their conduct. Additionally, the school cannot suspend the student out of school for more than 3 consecutive days. So there's no limit to the number of times in a school year that can happen, but if you have 3 days and then the following week 3 days and then the following week 3 days, and that adds up to the 10 plus days, if it's close enough together in time, then it will be considered an over 10-day removal. So then over 10 days, there are increased protections for children. There are going to be increased procedural safeguards and a manifestation determination review, which is a meeting with the parents and many other members. We'll be talking about that shortly, the manifestation determination review. So it's the same members that were on the ARD committee that we talked about earlier, and they meet to determine whether the student's conduct was caused or had a direct and substantial relationship to the student's disability, or was the direct result of the school's failure to implement the student's IEP. So those sound pretty similar, but they can be very different. You should pay close attention to the second one specifically, because that's where you might miss it. It's pretty intuitive to think this child has a disability. Was their conduct a result of the disability? And not so much to say, well, this child has a disability, they were supposed to be getting X service. Could this service be the reason, or this lack of service be the reason that they acted out in whichever way they did? So if the child's conduct was determined to be a result of their disability or the failure to implement the IEP, then the school has to conduct a functional behavioral assessment and implement a behavior intervention plan and return the student to the prior placement. So they can't do a disciplinary removal. However, there's one exception, which is if the behavior involved drugs, weapons, or substantial bodily injury, then the student can be removed. But if it was not determined to be a manifestation of the child's disability, then the same rules that apply to non-disabled students. So functional behavioral assessment is an evaluation used to develop positive behavioral supports in a behavior intervention plan. So these two things are very closely linked. And the idea behind a functional behavioral assessment is that all behavior serves a function. The child is either trying to get something or avoid something by the way they're acting. So the functional behavioral assessment's purpose is to identify the behavior and then identify what function the behavior is serving. So it identifies the things that could lead to the behavior, and then it tries to identify the behavior, the function of the behavior, and then some replacement activity. So an example could be if the child is acting out and disrupting the classroom to get attention. So the behavior is acting out. The purpose of that behavior, the function of that behavior is trying to get attention. And then we're going to try and find some activity that gets the child that attention that they need in a way that is not disruptive. So an alternate behavior, and that could be as simple as saying, if you raise your hand, I will be there by the time you count to 30. Or some other form that will make the child feel like whatever they were getting or avoiding, they can now get in a different way. So I've really just gone over this. It's the same thing. It helps the student engage in acceptable replacement behavior or decreases the student's desire to avoid whatever environment or situation is causing the unacceptable behavior. And this, especially with foster kids, can be a result of if there's any trauma, if there's anything going on with them that you know about that maybe the teachers don't know about, specifically with the avoidance. And there might be a trigger for them in the classroom that people aren't aware of.
This was all instances of fewer than 10 days?
Oh, and that was just for disciplinary removals. And this is just a functional behavioral assessment. So this is an actual assessment that the meeting, the ARG committee gets together and discusses and puts this in place.
As needed, not just once per year.
Right. So yeah, it's as needed. It's when it's determined that a student's behavior impedes his learning or the learning of others. But it's required when there's a disciplinary removal that's determined to be a manifestation of the student's disability. So who conducts an FBA? It should be a behavioral specialist or a psychologist, but the idea of the new federal law doesn't say who's qualified to conduct them. So commonly schools will ask teachers to fill out a form saying, what are these child's behaviors? Do they have X, Y, Z? And that can be really helpful in going into the functional behavioral assessment, but it's not, that itself is not enough. And that's not sufficient to be a functional behavioral assessment. So you can have teachers fill out those forms, but then you need to take those forms to the behavior specialist or psychologist, and that can help them in making their determination. So where does the information in an FBA come from? It can come from direct examination or observation of the student in their classroom. So for example, if the child is acting out in math class, the behavioral specialist or psychologist would actually go to the math class and watch the child in that environment in which the behavior occurs. They should spend more than an hour in that math class because obviously the child is going to be aware that they're there and that they're observing them. So we would prefer that they spend a few days. The information can also come from a student interview and talking to the child, or teacher interviews, or like I said, those checklists that schools often have teachers fill out, and then a review of their records. So common components of a quality FBA would be background information, a detailed description of where that information came from and what information came to light through these different avenues. A functional hypothesis, which is what we were mentioning earlier, what we believe that the function of the student's behavior is doing, a description of acceptable replacement behaviors, and a description of positive strategies to promote the acceptable behaviors, or positive strategies to reduce the student's desire to avoid the situations or environment. And then recommendations for the behavior intervention plan, which is another document that they create in conjunction with the FBA. And those recommendations would include the positive strategies to promote acceptable behaviors, or help avoidance of undesirable situations for the student. So here's just an example of that. And it says if a student engages in unacceptable behavior to gain attention, like we were talking about, the FBA would identify acceptable behaviors to gain attention in some other way.
Do you have an example?
Well, the example like I used before would be the child acting out in the classroom and they need to gain attention, so you say, if you raise your hand, I'll be there in a set amount of time. Or the child might be acting out in math class specifically when you're doing multiplication because the child doesn't understand multiplication. So the function of that behavior is, I don't understand, and then the child gets frustrated, and so the FBA might say, okay, well, this is the behavior, this is specifically when it occurs, this is the function. Maybe that child needs an aide or a tutor sitting next to them in math when you're on that subject, or maybe the child needs more specific attention in that area.
Okay.
So if you agree with the evaluation, you can tell the other committee members that you disagree, so you have it on the record. You also can notify the school officials that you want an independent evaluation like we talked about earlier, and that's one where you could ask the school officials for their criteria and then find somebody to do that independent evaluation. The school has to pay for one, and then the ARD committee has to consider the independent evaluation. So the behavior intervention plan is the kind of conjunctive form or evaluation. It's based on the evaluation data, including the FBA, and it has to include positive supports and interventions. So specifically positive, though, they can't be based on disciplining the child when they don't abide by the replacement behaviors that were suggested in the FBA. It has to be something positive, like a token system is a good example of a positive support. So these are specific tips for the behavior intervention plan, which is to be specific about each behavior at issue, and this is what we talked about earlier, the same kind of thing. Jane is aggressive is not specific, but Jane hits other students at recess when she doesn't get her way is more specific. So making sure you really focus down on what's going on. And then you can target a few key behaviors with specific individualized interventions. By saying give Jane an opportunity to exercise control is not specific, but give Jane the opportunity to choose the recess activity is. So we've largely discussed this, describe specific interventions and replacement behaviors, describe changes that could be made to the environment, and address effective methods of redirection. So that's just what I said earlier. Remember, positive behavioral support is not as much about changing adult behavior as it is about changing the student's behavior.
And that could be something as simple as making sure if your child has a contentious relationship with another child in the class, separating them, make sure they're not sitting by each other. It could be something as simple as that, or it could be sitting closer to the teacher so that they do stay focused. It could be simple things like that, but put it in writing so that they're forced to make sure that happens.
Yeah, absolutely. Especially because these records, as you all know, foster kids move around a lot. And these records are what follow the foster kid. So if you have it in writing, even though it might seem very simple, the next school personnel that look at it will say, oh, this kid needs to sit at the front of the class, which is something they might not have known otherwise.
Right.
So the committee also needs to determine whether the child can follow whatever the school's student code of conduct is, and if they can't, then that's another area where you can mention it in the BIP, specifically outlining where this child cannot follow the code of conduct. One thing to note as a surrogate parent is you should never, ever, ever consent to the use of disciplinary removal, law enforcement, or restraint. And that's as simple as going into the meeting and saying, I will not agree with the use of disciplinary removal, law enforcement, or restraint. And the district can still choose to do these, but it should be on record that you have not consented to that. So education services during suspension or expulsion. A district may be required to provide free appropriate public education during suspensions and expulsions. This is the distinction between the less than 10 days and the over 10 days. In less than 10 days, they only have to provide the same as would be provided to non-disabled students, and in more than 10 days, then the school must provide specific services.
Is being sent to an alternative school, that would count as not being suspended, right?
That would still count as a disciplinary removal. And they can only be sent to an alternative school for 45 days under a disciplinary removal. So there's also, if you think that your child might qualify for special education but is not yet in special education, there are some protections for these children as well. So the federal law might still apply if the school knew your child was disabled before the behavior that caused the disciplinary action. And schools have been held to have knowledge where the parent has written the district requesting special education services already. The parents requested a special education evaluation, and the child's teacher or other district personnel expressed concerns to district personnel. So if the school has knowledge of this, then the parent can request an expedited evaluation for eligibility. But they don't have knowledge solely where the child has been evaluated and determined to be ineligible, or where the parent has refused these services. So for older children, you have transition services, and these must begin not later than the first IEP to be in effect when the child turns. So that says 16. The law here has been very confusing. It started as 16, went to 14, went to 16. It's now 14. But of course, given the number of changes, times that's been changed, might be 16 again later. But right now it is 14. So when the child, the IEP to be in effect when the child turns 14, so that might be, there might be an IEP that was put into effect in September, but the child turns 14 in November. And so in that IEP that happens in September is when transition services must be considered. When you're considering transition services, the IEP also has to consider appropriate measurable post-secondary goals based upon age-appropriate transition assessments related to training, education, employment, independent living skills, determined by your child's situation.
And I can tell you, when sitting in an art and junior high and high school is much different than in elementary, because they do focus on these life skills and what are your plans for the future? How are you going to support yourself? How can we help you make that happen? So, I mean, they help them pick out which classes, change the classes if necessary, things like that. So if your meeting is not kind of run like that, just know that's the way it should be.
Especially for foster children.
Yes.
Because oftentimes, I mean, at 14 or 16, our children have very different life planning than children who are not in the conservatorship of the department. So although it might seem like their case is somewhat unrelated to their school services, this is where that is discussed. Where is this kid going next? Are they going to go to college? Are they going to get a GED? Are they going to be living by themselves? Are they going to be in a placement? And you can talk about all of that at this school meeting, and the school is supposed to help you decide what should be put in place to help the child with their post-secondary goals. So these are more transition services that should be included in the IEP or transition points. The transition services needed to assist the child in reaching whatever goals might be in place for the specific child. And beginning not later than 1 year before the child reaches the age of majority. A statement that the child has been informed of their rights under this title, and that will transfer to him upon reaching the age of majority as well. We are skipping around, but I know that the slide is in here somewhere. Regardless, you have an ARD before graduation as well, and the considerations there shall include recommendations on how to assist the child in meeting their post-secondary goals as well. So that's very similar to their IEP. And then restraint and seclusion. Seclusion is now banned. Students can't be in any sort of locked closet or locked room that is designated for the sole purpose of secluding that child and has less than 50 square feet of space. And restraint is very restricted. It's only allowed in emergency situations in which the student's behavior poses a threat of imminent serious physical harm to the student or someone else, or imminent serious property destruction. Unfortunately, restraints are used more widely than that, but that is the law. And then there are notice requirements to the parents also for restraints and staff training requirements. So the staff who conducts this restraint has to be trained within 30 days of the restraint,
So they're being trained once a month.
essentially. Well, after conducting the restraint. So
Oh, after.
Yeah.
That's kind of,
Backwards?
Yeah.
Agreed. There are also special considerations for children with autism. Under the Texas Autism Supplement, you have to discuss the following points before creating an IEP for the student with autism. So we don't need to go into detail about all of these, but if you have a child with autism, you should look back at this and note that specific things should be discussed for children with autism. And administrative remedies. This is if you don't agree with something that happens in a meeting, or you don't agree with something that's going into the child's records, and you've talked to the school and the school hasn't agreed to make those changes. There are numerous other procedures in which you can bring up that complaint. So the first is a TA complaint process, and that's largely for procedural problems, something that's more systematically going on with the school. So first try to resolve the problem with the school, but if you can't resolve it, then you can write a letter of complaint to the Texas Education Agency requesting an investigation in which you state the violation that occurred, the specific facts in which your allegation is based, and attach any important documentation. And then this just gives you the information on where to mail it. You can also request mediation whenever there's a complaint or disagreement. And to request a mediation, you also write a letter to the TA and include the names of all the important people in the school district. And then lastly, there's the due process hearing. You can request an impartial due process hearing. This is your very last resort. Resembles a trial somewhat. And you must request the hearing within 1 year of the time that something went wrong. And so this is just further resources and contact information. As Ms. Rees mentioned before, we are appointed in many cases specifically to deal with education issues. So if you have a case where you've got a lawyer on the case already and the lawyer is dealing with their CPS case, but you feel like something is really, really going wrong in this kid's school or their education, we can be appointed specifically to deal with that issue. And we deal with all of these things that we just talked about. And then that's contact information. Ian Speckler is the name of the primary attorney on the foster child team. And there's our website and then some other sources of law to look at if you're ever having a problem. You can also feel free to call us if you have a specific question. We don't need to be appointed on a case to give out advice or send you to a specific resource. So.
They've been very helpful.